Yeah, hello and welcome back to the channel. Now we are going to approach the third chapter of our lecture on double taxation or international taxation as a whole. Today's topic and the topic of the next videos will be the basics of double taxation treaties. So the you come close the matter where or you can understand what we are going to talk about now is when you first think about who decides which method for the avoidance of double taxation is applied and when does that happen. Well, that is simply the law. So we can only now ask which forms the law can take. And there are two possible ways. First, the state can create solutions of its own. So that would be a so-called unilateral solution. Then you just write methods to avoid double taxation into your home state law, your domestic law, and that's it. The other way is you make an agreement with another state where you talk about how the problems of double taxation shall be dealt with by both states together. So that is a bilateral solution, and that solution, as it is founded on an agreement, is then laid down in a treaty, or you can call it a convention, an agreement, or however. By the way, in literature, at least in the English-speaking world, you really have no standard term. You find double taxation treaty, you find double taxation agreement. Some people speak of double taxation conventions, so it's all the same, evidently. But the basic characteristics are that two states make a treaty, an international agreement, which regulates which state has to do what in order to refrain from double taxation or to restrict it or to lower its extent and so on. In theory, there might also be an agreement between more than two states. Then we would have a double taxation agreement or double taxation treaty, which has a multinational or multilateral nature. That is or has been up to now not very frequent. There is at least one multilateral convention for the avoidance of double taxation, which I know of. That is the multilateral agreement between the Nordic states, so Scandinavian states. And then there have been on several isolated matters or topics of double taxation more and more multilateral conventions during the last years. So there has been the multilateral instrument, the so-called one, which amends all the existing double taxation treaties in several isolated points. And there is going to come, it is planned, a multilateral convention on a global minimum taxation. But the standard solution is still the unilateral or the bilateral one. Well, so clearly it can be said that the law always counts and that there can be unilateral, bilateral, or even multilateral ways to establish rules for the avoidance of double taxation, the ones which we know, the four methods, into a legal text. So that is where we have to start with. Examples for a unilateral solution would be the German rules in 34C ESDJ, where Germany says what it does if there is no double taxation treaty or any other special rule applying to the individual case. The bilateral solution are the double taxation treaties between two contracting states. That would be, in the case of Germany, at least approximately 90 agreements. Now we have approximately 207 or 210 independent or dependent but autonomous territories which have their own tax laws worldwide. So with a quota of 90 treaties, Germany is relatively well off, covers 50% of the existing states and probably the overwhelming percentage of the worldwide trade relations and business relations, because the states which do not show up on the list of double taxation treaty partners are usually the less important states or statelets. For a multilateral solution, you can name the Nordic countries, or you could name the arbitration convention between the EU states on conflicts concerning transfer pricing, the Vienna Convention on Diplomatic Relations, where it regulates the taxation of diplomats in the host countries, the multilateral instrument, which is going to, or which has, or is on the way to amend all existing double taxation treaties in special aspects, or you could even name the multilateral convention, which is planned on global minimum taxation. Well, standard case is, again, to say that the bilateral solution. So we have treaties between two states. So that is where we are going to talk about now. And the first question is naturally, what can you now expect inside a double taxation treaty? And which kind of rules or statements can never be expected to be found inside such a treaty? Well, let's begin with the last question. What will a double taxation treaty never contain? And the answer is it will never contain details which would perhaps make changes necessary in the short term. So what would, for example, happen if you fix a detail as a tax rate for a foreigner in a double taxation treaty? Imagine at the moment the German corporation tax is 15%. Now imagine you write a double taxation treaty with America, and then you put down there the rule that the German permanent establishment of an American corporation has to be taxed in Germany with a rate of 15%. What would happen if Germany now wants to increase the rate from 15 to 20%? Before that becomes effective for an American, you would have to change the treaty with America. That takes some years. An international agreement must be negotiated, it must be agreed on, it must be presented to the parliaments involved, it must be signed by the heads of state, it must be confirmed by ratification between the two states that both now have agreed indeed to stick to that agreement from now onwards. And that takes years. So imagine you fixed a rate of 15% in the text of the treaty. Before you can change it there from 15 to 20, it probably takes 4, 5, or 10 years. And now imagine you have 90 treaties and everywhere there is for foreigners 15%. Before you have adjusted all that to the now planned 20% rate, probably you already intend to go down again to 15 or to 10 or even to 30. So you would have a constant chaos. That is the reason why details like the tax rate are never fixed in a double taxation treaty. The same applies, for example, when it comes to the tax base computation. Imagine you have a rule that certain provisions must be made in the tax balance sheet for liabilities which are caused and have to be paid in the future, for example, for damages. Now imagine you want to abolish that provision. In the national law, you can do that quickly. And now, if that were then fixed also in the text of 90 treaties, you would then have to change 90 treaty texts. That would take 10, 15 years or so. And when you are through with that, you probably have already the next changes on the list. So it would be a constant chaos. And foreigners would never be treated effectively alike than their local competitors. You would never get a level playing field, where foreigners here would be subjected to the same rules as their local competitors. It would always be too high, too low, too different or so. So all this is excluded from the treaties. And you say this is only fixed by national domestic legislation. You can never ever fix details like this in the text of such a double taxation treaty. Now you will naturally say, what is then the use of, or what will be the contents of such a treaty if all the important things cannot be regulated there? The tax base is not laid down there, the tax rate. Well, so you think you get no information from such a treaty. How can it work? And the answer is, well, plain and simple. The double taxation treaty just restricts itself to saying which state can apply its law, its legislation, its tax law to which income, and which state has to refrain from doing so. So the double taxation treaty only states if a certain income may be taxed by a certain state or not. All the details. If, for example, the double taxation treaty says Germany is allowed to tax a factory within Germany if the owner is an American, then that's it. That's the only message. So Germany is allowed to apply its tax law to the factory in Düsseldorf, although it's owned by an American citizen. And for example, the Americans are obliged to credit the German tax to the American tax, or what else. But the standard message is you are allowed to apply your tax law or you are not. So if you then are allowed to apply your tax law to the situation, then you would simply do the following. You looked into the DTT, got the information the Germans may tax the factory of the American national in Düsseldorf. Then you open the text of that tax act, look into it and say, okay, the owner is an American citizen, does not live in Germany, so limited tax liability. Then what does limited tax liability rules of German law say on a factory of an American or a factory located in Düsseldorf? Do we raise a tax claim under the national legislation or not? Well, we do. What does national legislation then say about the computation of the tax base? Okay, profit, income from business. Okay, so all the details come then from national legislation, and that makes the thing so nice, because you have 90 treaties which only say German law can be applied or cannot be applied. And now when the tax rate in German law is 15% and you want to increase it to 20%, you do it on the 31st of December with effect from the 1st of January following. And at midnight, when the 1st of January comes, taxpayers from 90 countries look into their DTTs and say, I can be taxed in Germany under German law. And then second step, they open German law and surprise, the rate is 20% now since midnight. So now you have a flexible regime. You can treat people equally. All the people who are in the German market, where Germany said, okay, they are taxed under German law, according to the DTT. When German law is to be changed, it is directly changed for all the people involved. You never need to change 20, 30, or 90 treaties. So if there is a change in the legislation, it directly becomes effective for all people for who it applies. That is the charm behind that mechanism. So here, again, as an example, because that is so important, if the DTT between Germany and the country of Faroestan says the income of a Faroestani from letting a German house to tenants may be taxed in Germany, then that means Germany may apply its tax law to the rent from that house. And then if Germany really levies a tax on that, and how high this tax shall be can only be found out by looking into the German Tax Act. Now, if a faraway Estani is a national person, it's a clear thing that you can find that out in the Income Tax Act. And well, lease and rent from a house would be income of under 21 ESTG. So you look there. The tax base is the surplus. You compute it according to German rules. The tax tariff, how it has to be applied to limited taxpayers, you can all and everything find there. So that's it. So if a double taxation treaty allows a tax for a state, only the national law of that state decides if that state really wants to make use of that right or not. So the state can decide to levy a tax, or it can decide not to levy a tax. This is only a matter of national law. Imagine, for example, there is a double taxation treaty between Germany and Faroe-Island, which says if a Faroe-Istani citizen owns a piece of land in Hamburg, and that piece of land is sold, then Germany and only Germany can levy a tax. Okay. Then, if that has happened, you look into the DTT and find the information Germany is now allowed to levy a tax. And you look into the text of the Income Tax Act, let's say a small booklet, and begin to check the case. Okay, we can apply these tax acts to you now. You live in Faroe-Island, yes. You do not have a residence in Germany, yes. You do not have a habitual abode in Germany, yes. So you are a limited taxpayer, yes I am. Okay, paragraph 1.4 ESTG, okay. Then let's look to the special income tax catalog for limited taxpayers, paragraph 49. Yeah. Income from lease and rent, is it on the list? Yes. But only if there is current income, yes. So you sell now a piece of land, yes. That's not a current issue, that's alienation of property. And if it's private property, there is a famous paragraph 23 ESTG. Private property consisting of pieces of land and houses are only taxable if they are sold within the first 10 years after acquisition. Yeah. How long did you own that piece of land? 20 years. Okay, then it's no income under the 7 types of income. It's not a part of your worldwide income. It's not a part of your German income. It's no income at all. Germany doesn't raise an income tax rate. Congratulations. So we have the right to levy a tax, but we don't do. That's possible. So let's go on a bit. So what you can now follow from that whole system is that a double taxation treaty alone is never a sufficient base for claiming tax, because as you saw in the last example, the double taxation treaty said Germany may levy a tax on selling a piece of land in Germany, but German law then said, well, we don't. So for a tax claim, you need 2 things if a double taxation treaty exists. First, the double taxation treaty must still grant to a country the right to apply its laws to that case, and afterwards in the national legislation, in the domestic legislation, you need to find a sufficient base for a tax claim. On the other hand, if a double taxation treaty does not allow a state to levy a tax, then it's usually a clear command. So you know that national legislation must come to the final result that the state doesn't take a tax. That's just if in the national law, for example, you have a claim the worldwide income must be taxed, and now the double taxation treaty says, well, German law does not apply to the permanent establishment in France, then you would have the DTT prevailing as special law with a clear command. The profit from France, from the French factory, must be left out, so it must be interpreted as being tax-free under German law. So If a double taxation treaty forbids taxation, that's usually precise enough. Whereas in other cases, when it allows a taxation, you need to check if national law makes usage of that permission and in how far and how that tax is then levied. Good. Few examples. First, what does the DTT say about the rights of Germany? Let's say Article 7.1 of a double taxation treaty with Faroestan says Germany can levy taxes on the profit which a taxpayer from Faroestan has from a permanent establishment in Germany. Now, okay, this says Germany can tax, let's say, factory in Germany. Now, next question is, does Germany make use of this right and in how far? 1.4 ESTG says the taxpayer from Faroestan is limited liability taxpayer, so we have to apply the rules for limited tax liability. 49 number 2 letter A ESTG says in the case of a permanent establishment in the inland, a limited taxpayer is taxable with the profit from that. And then what the profit is also determined by the Income Tax Act, paragraph 4. Which tariff has to be applied can be found in paragraph 50 ESTG, and that gives a reference to the usual tariff in 32A ESTG, and so blah blah. If you enter the tax rules more deeply, you get more and more into the details about this case. So there you find all the details. The DTT only says look into the German law for the factory profit, and that is what you have to do afterwards. Another example, imagine a dividend from Germany comes from a German corporation and that goes to a Faroestani investor. So Article 10.2 double taxation treaty will probably say that the dividend can be taxed in Germany up to 15% of the dividend gross amount. Now we must find out if Germany really uses that possibility. And so you look again into the German law. Let's take a small booklet and look it up, or the text slides or so. Now, we have again a limited tax liability taxpayer. And so we will use the special catalog in paragraph 49 ESTG for inland income of limited tax liability taxpayers. And that says a dividend paid by a German corporation is taxable, also under limited tax liability rules. The next step will probably be how will that tax have to be collected. And here, for dividends and interest income, very often there is a special form of tax collection that is a withholding tax. The person who pays the amount to you, that's here the German corporation, has to hold back a part of the amount which you have to claim. So here they have to withhold a part of the dividend and transfer that amount not to your bank account with Deutsche Bank or a bank in London or a bank in Faroestan, but to your account at the fiscal authorities of Germany. So they pay in your name this 25% withholding tax as a kind of a prepayment on your personal income tax on that dividend. That this has to happen and that this has to be done by the person who pays out the dividend, and how that has to be calculated, that withholding tax, all that is laid down in the Income Tax Act naturally too. You find it in paragraph 43, which states which events trigger such withholding tax obligation, and 43A says how high the withholding tax has to be in relation to the gross amount. Here 25%. So 49 says yes, it's taxable income. 43 says there is a withholding tax on that. And now the next question is, as a withholding tax is a payment in your name to the fiscal office, a prepayment for your final income tax. Will you later have to hand in a tax declaration again? Also, that is a matter which is entirely decided by German domestic law. Germany gets by the double taxation treaty a right to take a tax, and we alone decide how high it is, how low it is, how it is to be collected, which authority gets the tax declaration, if any, and so. But here we have one thing which we can clearly see. The double taxation treaty allows 15% as maximum, and now German national law says 25. Now we have still to find a bridge between the 25 and the 15. And Germany and many other states decided to say it's far too complicated to let your business partner decide if you qualify for the reduction to 15% under the double taxation treaty. Most people never open the double taxation treaty up in their lives. It's difficult to understand, and it's difficult to check if you are really entitled to the privileges of that double taxation treaty, or if that all might be an error, shame, a tax saving construction which is not acknowledged by the fiscal authorities or what else. And so the double taxation treaty and the 25% rule must be brought together in a different way. Here, the taxpayer, it's usually done in a way that the 25% are withheld. You get a receipt on that by the dividend paying authority, corporation. And then you address yourself to the tax authorities with a right to claim the refund of 10%, which were withheld in excess of the legally allowed 15%. So that's a kind of ping pong. Yeah? 25% are given to the fiscal authorities, and then you claim 10% back, and that's pong. Ping is there's a payment, it's too much. Pong, you get it back if you apply for the refund. That's possible because the DTT only says in the end Germany has a right to keep 15%, and if we claim 15%, how we claim 15%, and in which way we claim 15%. We might claim 80% and refund 65%. I hope that was correct. All that is our personal discretion. That is all regulated by German law. So that is how a double taxation treaty works. Again, to illustrate that, let's say Article 13. And here we have the legal background now for the example which I gave in the beginning. You sell a house in Germany. Article 13.1 says if you sell immovable property situated in Germany, only Germany can tax this. How does Germany make use of this right? And the answer is, well, you are a limited tax liability taxpayer. Article 1, paragraph 1.4. Paragraph 1.4 says use the specific catalog of inland income under 49. 49 says selling an inland private property, real estate, is taxable if sold within the first 10 years of your possession. Now, if you sold that house after 20 years, Germany has the right to levy a tax, but Germany says, well, no, we don't. So if that makes clear that if a DTT says the state may levy a tax, this only gives permission to the state to levy a tax. If they do it or not, and how they do it is only a matter of domestic law. So the faraway tiny owner of the German house would not have to pay a tax in Germany, and that would not be an unfairness or a big surprise, because Germans who do the same would also have not to pay a tax after that 10 years holding period for real estate property. Wow. 11.2. Interest income. Again, an interesting constellation. Imagine 11.2 of the double taxation treaty with Far Away would say that Germany can levy a tax up to 10% of the gross interest payment. Now, next question, how does Germany make use of the right? The first thing would again we look to the foreign recipient of the interest income, and that foreign creditor, imagine he or she has neither residence nor habitual abode in Germany, so limited tax liability applies. One for ESTG. When we look to 49, the catalog of taxable inland income for limited tax liability, and then we make a surprising detection. We see that paragraph 49(1) does not contain any tax claim on regular plain interest from a credit given to Germany to a German business partner or so, if that credit is not secured by a mortgage on a German piece of land. And naturally now it is a clear thing, if you have any other possibility for a collateral, you would never choose a German piece of land if that triggers a German tax claim. It makes life complicated. So only an idiot would probably insist on a German mortgage in the favor of a limited tax liability taxpayer, because that triggers a tax claim. All the other forms of collecting the interest do not. So Germany, in the end, could levy a tax, but it does not. Surprise. So that's it. Sum it up. If a double taxation treaty gives the right to levy a tax to a state, this state can freely decide if it wants to make use of that right or not, and if it wants to levy a tax or not. And if it levies a tax, it can absolutely decide on its own in the national legislation according to which rules that tax will be computed. So if there is a tax claim or not, if you tax the profit or the surplus, how you calculate the profit and the surplus, which tax rate you apply, on which grounds the tax base is determined, on the grounds depending on how high the income is, depending on if you have overweight, depending on how old you are, depending on how many elephants you have in your garden. All this nonsense would all be permitted by the system of the double taxation treaties, because they only say which country is competent to levy and define a tax claim. So you are not even bound by logic or fairness or so. The DTT only says you can levy a tax, and then the rest is yours. If you want to insist in fairness, you can only apply to national courts there or constitutional rules. Let's say if fairness is in the constitution for tax, you might address the local courts, but under the DTT you have no claim whatsoever to fairness. Fairness and taxation, that's a contradiction in itself, at least from the point of view of the fiscal authorities, perhaps. So you are not bound to follow certain rules. By the way, that can be illustrated very well by the interest example again. Imagine again, if interest is paid to a creditor abroad, Germany is permitted to levy a tax of 10% maximum. Now, if that taxpayer has no residence and habitual abode in Germany, Germany doesn't use that right. We have already seen that there is no tax claim for regular interest under the limited tax liability rules. Now imagine our taxpayer has a secondary residence in Germany. So main residence in Faroestan and a second home near Munich. Why not? People with money sometimes have several homes. Why shouldn't they renounce that? But now, nice surprise. You check the case again. Germany may levy up to 10%. Now you check the national legislation. And now, surprise, first you check if the taxpayer is subjected to unlimited tax liability. Unlimited tax liability applies to everybody who has a residence in Germany. That means one residence is sufficient, even if it's a very, very secondary one. So here our taxpayer is classified as unlimited liability taxpayer. That means the worldwide income is taxable in Germany, apart from those parts which Germany renounced under the Double Taxation Treaty. Now imagine Germany renounced on everything in the Double Taxation Treaty in the favor of faraway stuff, apart from the interest income. Okay. Now under the unlimited tax liability, there is a tax claim on income from capital, on all income from capital, 25% flat rate. So our taxpayer will be taxed with 25%. And now the Double Taxation Treaty says the limit is for dividends 15%. That is a typing mistake here that I mentioned the 15%, because if you look at the first line, we talk about interest, and there the limit would be 10%. So Double Taxation Treaty says 10% can be taken. German law says, yes, I want to take. Because this is now an unlimited tax liability taxpayer, I take 25% general rule, reduction by the specific rule, 10% is the maximum. So we take 25 and an application refund to the taxpayer, the exceeding 15%. Now, if you look to that specifically, you see, hey, DTT permits 10%, and there are situations where we make use of that right and others where we renounce on it. And the criterion is just if the taxpayer has a secondary residence here or not. It has nothing to do with his or her ability to pay. So with a reasonable criterion. And that shows you, well, a state is not obliged to act reasonably in writing its tax laws. So the present situation makes no sense, but we are allowed to do so. And that, again, underlines, ladies and gentlemen, why it is so important to see this two-step approach. First, you look into a DTT in order to find out if a certain state has a right to apply its tax law and if there are limits. And the second step is then look into the national legislation, how you are taxed there and if. Good. Now, by the way, if you read textbooks or other introductory literature which teaches you international taxation, you very often find a different arrangement of the two steps. If you have a teacher from the fiscal administration, they first say, look always into the national law and then into the DTT, if there is a limit in the DTT. From the perspective of the fiscal authorities, that's absolutely right. They, for example, if they have no tax claim and a paragraph 23, they do not need to open up a double taxation treaty because they know they are not meant to issue a tax notice for that event. But that comes only from the specific situation of the fiscal authorities. A fiscal officer only cares for the German part of the case. What is not a tax claim for Germany does never interest the German tax officer. So they look into their law. If there is no tax claim, they don't bother about the rest. Now, if you are a consultant for the taxpayer, your interest is completely the other way around. The first thing you want to find out is, before you look into the law, in which state's law do I have to look? Because imagine you spend 3 days in finding out the complex legal situation under German law for a certain event, and then you look into the DTT if there is a modification, and the DTT says, oh, surprise, faraway town law is competent, Germany is out. So you wasted 3 days. Or if the DTT says you are taxed in Spain, it makes no sense to speak with a German tax advisor on that. There is only one thing which you can talk about with the German tax advisor. That is, which Spanish tax advisor should we ask? Everything else is a waste of time. So from the perspective of the taxpayer, the sequence of checking the things is completely different. It's the other way around than the standard way which the fiscal officers and their teachers always bring into textbooks. The private person or the corporation first looks into the DTT. Which state law do I need to find out and apply? And then you go into the domestic legislation, first investigating German law for hours, and then finding out in the DTT that German law does not apply. That's a catastrophe which nobody wants to have. Okay, that's enough for a single video. Keep in mind the two-step approach. DTTs only allow which state applies its law. All the details always come from then looking into the national law. The details might be completely chaotic. That is something which the local state just decides. And the reason was you can't fix details in a DTT because otherwise the system would be completely inflexible and completely chaotic. Automatically, you could never enact any change. Okay, the next question which we have to talk about will be how binding is a DTT in practice, and that is enough for a second video. So goodbye for now. You know, again, if you survived this video up to now, might press the like button, recommend it to others if you like it or not, and come back to the channel when the next video is published. Thanks and goodbye till next time.